This talk in the Social Care Law lecture series considers the way a care plan for a disabled person, an older person, is prepared. In a previous talk, we considered the process by which a social services authority decide whether somebody has an eligible need. Essentially, we saw that consisted of asking a simple question. What if we don't provide this person with help? What will happen? And the more serious the answer, the more compelling will be the need for something to be identified as an eligible need. In this talk, we look about how these eligible needs are converted into a care plan, which lists the services that must be provided to meet that need. In this talk, we consider the law in England and Wales, and as I've said, it also looks at the law relating to people of any age with needs, disabled children or older people or disabled adults. At its simplest, a local authority might decide that somebody with a mobility difficulty needs to access their home safely. That's the need. And they might just respond by saying that the way they're going to meet that need is to provide a ramp, and that would be the service. The care plan would have to say when the ramp is going to be put in, who's going to put it in, where it's going to be put in, and so on. And that would be a very simple care plan indeed. We're going to see that in general, care plans are going to be much more complex than that. Now, this talk is divided into 7 different sections. We're going to first look at the law, which states quite clearly that an assessed need must be met. We're then going to consider guiding principles. How do we decide which way a particular need will be met? We'll then look at the detail of what must be in a care and support plan. Sometimes a local authority, instead of providing services, will give the individual direct payments, and sometimes they'll call that a personal budget, and we'll, in section 4, consider that question. We'll then look on at how care plans are reviewed and how they may be reassessed. The next section will look at how you can challenge difficulties with a care plan that you disagree with. And the final section, section 7, are further resources and materials. These are follow-up materials that will enable you to study the issues we're considering in this talk in greater depth. They'll include statutes and the relevant case law and course materials and articles and so forth. A local authority may decide that somebody has an eligible need to keep clean. They may have had a stroke and have an inability to wash themselves. They may have a long-term physical impairment that causes the same problem. Or they may have a learning disability or dementia, not even be aware that they need to keep clean. A local authority might decide somebody has an eligible need to help with feeding. They may need help shopping, or they may need help preparing food or cooking food, or they may just need food delivered to them, or they may need actually help swallowing. A person may be acutely lonely, they may be isolated in the community, and they would have a need to socialise and get out. All of these are needs, and if they're eligible needs, they must be met. And that's the key part of care planning that we've always got to remember, the key legal issue. Assessed needs, eligible needs, must be met, and they must be met regardless of resources. A local authority has got to meet that need as soon as practicable, and if, for instance, the ideal service, the appropriate service, isn't available, then it's going to have to say what it's going to do in the interim. We're not going to have waiting lists because the local authority is short of money, and as we saw in the previous lecture concerning assessments of social care needs, panels and other devices where senior managers try to restrict needs to meet resources have been frowned upon by many courts and ombudsman's decisions. A case that is a good example of the legal principle I've just mentioned, that needs must be met regardless of resources is the case of Tucker and the London Borough of Sutton. Teresa was profoundly deaf, and she had learning disabilities. And a major problem that she had was communication was very difficult for her. It was thought that she needed to be in a specialist setting, a small setting, a local setting, a non-institutional setting, and in a setting in the London Borough of Sutton. Such a placement didn't exist in Sutton at that time, and many of these placements are provided by a charity called Sense that has got the skills to deal with people with those types of impairments. Sense said that they didn't have a setting in London, but they did have one in Birmingham. The problem was that part of Teresa's assessed need was that she should be near her family in Sutton, and there wasn't anything there, and to go out and create a service there would have been very expensive indeed. And so what happens is that nothing happens. Teresa spends another 2 years in hospital, whilst the local authority effectively hang around, hoping that something will turn up. The case eventually comes to the High Court, and the judge makes a simple statement of the law, which is assessed needs must be met. There has been an assessment of Teresa's needs, but there hasn't been a care plan. Nobody's identified where she should go. And the court orders that the local authority come to court within 21 days with a care plan explaining how Teresa's needs will be met by a specialist provider in the Sutton London Borough area. Now that may have cost £250,000 to provide each year. It may have cost even more, but that doesn't really matter because once a need is identified, it must be met. Of course, if there were various providers, then the authority could have chosen a cheaper one. If there aren't, then it has to go out and basically tailor-make a package. So how do we decide how an eligible need, an assessed need, will be met? What services are appropriate for it? The way that that's done is by a social worker working with the family. That's often known as person-centred planning, self-directed support. The person's views, the individual who has the needs plus their carers must be fully involved. I've just outlined various scenarios. Somebody perhaps who needs help washing. They have restricted mobility or they have learning disabilities, so they need help washing. There are various ways we could meet that need. We could provide them with a strip wash. We could provide them with a downstairs purpose-built wet room. We could give them a stair lift so that they could access perhaps their upstairs bathroom. There are very many community care ways that we could meet that need. Somebody may need help with food. Does that mean they need help shopping? Does that mean that they need to help with preparation of food? Does it mean that we need to teach them how to use the internet so that they can internet shop? Or does it really mean that we'll just deliver a frozen meal and give them a microwave and they can put that in and sort themselves out that way? Somebody may be very lonely. They may become isolated. They may be becoming depressed. Do we meet that need by putting them in a day centre with other disabled people or older people? Or are there other ways of doing that? Might they want to go to the pub, or might they want to go and watch football or some other activity? How do we decide which way we're going to meet those various needs? In order to decide how we're going to meet somebody's needs, how the state is going to meet the needs, there need to be guiding principles. The law talks about a duty to promote well-being, which is very fine, but very vague too. I think at law, however, there are a subset of principles which are more important. I think there are 5 that we need to consider in this talk. The first one we don't need to spend much time on, and that's the principle of non-discrimination. People should have their needs met regardless of who they are, regardless of whether they've got learning disabilities or Alzheimer's disease, regardless of whether they've got a mental illness or a physical disability. Needs are met, not the category of person you are. But the other 4 principles, I think, are particularly relevant in this talk. And they, to my mind, are the principle of dignity, independent living, choice and cost effectiveness. We have our needs met. We have a right to have our needs met with dignity. I may need to keep clean. I may need to go to the toilet. I may need many physical activities, help with very many physical activities. I could have a ground floor extension which would provide a wet room and a toilet which is accessible for me. I might have a stair lift, a through floor lift which helped me access a bathroom upstairs. But the local authority might say, well, we think a commode and a strip wash would meet your toileting and bathing needs. And the answer, I think, would be yes, it might meet those needs in a functional way, but it doesn't meet it with dignity. Social services must provide support in such a way that it doesn't subject people to indignity. And indignity it may be a vague term, but I think that we all have a fairly good feeling for that. So if one's challenging a care plan, one would use the dignity word. I think it's an important word. If somebody has a need to, let's say, be bathed, be fed, socialise, then the local authority might make community activities available, adapt their home and provide care assistants to come in and help them. But it might say, well, we can put you in a residential care home because that residential care home will do all of those things. It will keep an eye on you, it'll feed you, it'll have accessible bathrooms, and you'll have other people there that you can talk to. That, again, might functionally meet your needs, but there is a principle, a very important principle of independent living. People should be able to live as independently as possible. In fact, Article 19 of the UN Convention on the Rights of Persons with Disabilities enshrines that right. So I don't think a local authority could place me in a residential care home or in some institutional setting simply because it was cheaper than keeping me in the community. That's a general principle. It's just the same as I don't think a local authority could subject me to indignity simply because it saved them money. The third principle is choice. In general, people should be able to choose their services. They should choose the setting of those services. They should choose where they live and with whom they live. And if there's a choice over whether I go to the pub or whether I go to a day centre or whether I start a small business, if I need to get active in the community, then it should be my choice. But choice has limitations, and that's where it comes into conflict with the fourth principle, which is cost effectiveness. If a local authority can meet my need with dignity and promote independent living, and it can do that in a particular way that is less expensive than the way that I want to meet that need, then the local authority can say, no, we're not going to fund your choice because your choice is more expensive than an alternative way that we're proposing. But that alternative way must meet my need. And that alternative way must be actually available. It must be a concrete service that the local authority is pointing to and says that service exists and it's available. If they do that, then I can't effectively trump that with my choice. I would be able to take what the local authority is offering, maybe a direct payment, and then have to top up the balance. Once a local authority has decided with the disabled person and their carers how a need is going to be met, then it's got to be written down in a care and support plan. Very much like if you've decided how you're going to renovate your house, you're going to get somebody to write down very precisely all the technical specifications so that we know what has been agreed and if something goes wrong, how we can challenge it. So that's an important point. We're going to need, once we've produced a care plan and we've had it written down, we're going to need a copy of it because we're going to need to be able to hold the local authority or to private providers to account. So a care plan must spell out the wicked detail, and the courts have said it's basically got to provide the how, the when, the what and the where. It's got to provide that technical level of detail. And in a series of court cases and ombudsman's reports, we can discern effectively the sort of detail that we should be looking into a care plan. We should be reading into a care plan. So the care plan must spell out what the assessed needs are, what the eligible needs are, and then how those needs are going to be met. So those would effectively be two sides of an equation. These are my assessed needs and these are the services. They're going to have to tell us the level and frequency of the help that is to be provided. How often is somebody going to come in and help me bathe? How often is somebody going to come in and help me wash my hair, for instance? How often am I going to be able to go into the community, to go 10-pin bowling or to bingo or to the pub or whatever my activity is? Who's going to provide it? Which agency is going to provide it? Which individual is going to provide it? Who is the person I'm going to have to contact if things go wrong? Why are they providing that service? What is the outcome? The outcome is for me to meet people. The outcome is for me to be properly fed, to make the choices that I wish. And the times and the dates that these things are going to happen with some provision, and what's going to happen on a bank holiday or when somebody is ill. And what are carers, informal carers or family friends are going to do? Because part of the package might be that some of the needs are going to be met by carers who are willing and able to do that. So we're going to have that spelt in the plan. Who's going to coordinate it? What's the contact number for that coordinator? And as I've already said, what are the contingency plans if things go wrong? And who is monitoring the care plan? And when is the review going to take place? So that's the level of detail. And as I've said, in a famous case against Caerphilly Council, the judge said, look, this has basically got to have the how, the when, the what and the where. A good case that illustrates a care plan is the case of Rickson and the London Borough of Islington. Jonathan Rickson has significant impairments, learning disabilities, and he needed to be out of the home where he lived in a safe, supported environment that was stimulating, that had people that could had the skills to manage his particular needs. Islington Council looked around and there wasn't a lot available during weekdays for Jonathan, but they saw that there was a Mencap day centre and they thought that that would best meet his needs. And there really is no dispute in this case that that was the appropriate service. The problem was that the day centre was full, and so the local authority put him on a waiting list. Now, Jonathan eventually took proceedings, or proceedings were taken on his behalf, because he said, or said on his behalf, once you've identified a need in his case to be looked after in an appropriate environment, stimulating environment during the day, then that need's got to be met. And putting me on a waiting list is not meeting the need. It's saying, well, maybe in the future we'll meet that need. It's not a care plan, it's a wish. Islington, on the other hand, said, well, we can't magic out of thin air a day centre. There simply isn't one in Islington at the present time, and therefore what else can we do but put him on a waiting list? The case goes to the High Court and Islington lose that case. The High Court accepted that Islington didn't have a magic wand. It couldn't produce a day centre out of thin air. But the court said that that's not really the issue. The issue is that Jonathan has a need and you're not meeting that need. You've identified an ideal way of meeting that need, but it's a hypothetical way. So yes, put him on a waiting list, that's fine, but what are you doing in the interim? What are you doing now? What services are you providing to get him out of the house, to keep him safe? It's who is calling, where's he going, is there a drop-in club he can go to, is there a care assistant that can go in, is there somebody with skills that can deal with his needs in the interim until that day centre place becomes available. And the court also said that apart from dealing with the short term, the local authority would have to address the long-term issue, that it seemed to the judge that there were insufficient day centre places or placements for people with needs like Jonathan in Islington, that Islington had effectively to go out and prepare a strategic plan how within a relatively short period of time they would increase the capacity, the supply of support for people like Jonathan. And so the care plan in his case would have to spell out the short interim services that would be provided, the medium term, and how that would be sustained into the future. In general, once somebody has identified eligible needs, assessed needs by the local authority, then that person, a disabled person or the parents of a disabled child or an older person, can insist on having those needs met by way of a direct payment. That's a cash payment to meet the needs. They don't have to give reasons why they want a direct payment. It's the statutory obligation on the local authority to allow people to have a direct payment. The amount of a direct payment must be enough to purchase the needs that have been identified in the assessment. And a local authority will have to explain how it's arrived at a calculation so that it does meet the assessed needs in full. Frequently, local authorities will have what I call going rates. They'll say that our going rate for an hour's home care is, say, £15 an hour or something like that. That's fine, that's a good rule of thumb, but it may not be appropriate in every case. Somebody may have a need for a special assistant who's going to be more expensive than that. So these rates are not chiselled in tablets of stone, they're negotiable. And ultimately, if a person thinks that the direct payment package is insufficient, then they can go through the complaints process. Of course, if you get £15 an hour in a direct payment, that doesn't mean you're paying the individual £15 an hour or you're paying the agency £15 an hour, because there will be contingencies. There will be insurance costs if you're employing somebody, training costs, there'll be sickness payments, there'll be national insurance costs and things like that. Local authorities also, particularly in England, give families and disabled people a statement which is what's called a personal budget. And sometimes personal budgets are used almost synonymously with direct payments, but they're actually technically slightly different. In this talk, I'm not really going to go into details about personal budgets, or indeed the detail of how you calculate a direct payment, the very fine detail. That information is at the end of the talk in the resources and materials section. The one thing we need to know about a personal budget, however, just like a direct payment, is that it must be enough to meet the assessed need. It can't be an arbitrary figure, it can't have arbitrary ceilings or maxima. And the courts have repeatedly stated a local authority must be able to explain to an individual precisely how that budget or that direct payment has been calculated, so that if they think it's insufficient or if they think that there are aspects of the assessed need that are not being covered by that payment, then they can make a complaint. They can know where they stand. As we've already said, one of the elements of a care and support plan is a date for the review. Customarily, care and support plans will be reviewed every 6 months or 9 months or every year. Sometimes those reviews are fairly cursory, but the idea is that a care plan will be reviewed to make sure that it's still fit for purpose. Somebody's needs may have deteriorated, they may have changed, and so we may need to change the care plan, increase the amount of support, and so on. Now, unfortunately, sometimes local authorities use reviews as a way of trimming care packages if the local authorities had a financial problem, and most of them have in the last few years. If that happens, then we need to go back to the original assessment and say what has changed. What is the basis for you saying that you want to reduce this care package? And a good case that illustrates this is a case called Killigrew and Birmingham City Council. The case concerns Deborah Killigrew, who has multiple sclerosis and who was registered blind, and she had very substantial care needs. And she was receiving a package of 12 hours home help support, amongst other things. A review was scheduled, and during that period her multiple sclerosis had deteriorated and her needs had increased quite significantly. But nevertheless, the local authority said that they thought that her care needs could be met by a smaller package, that she needed significantly less than 12 hours home care each week. The case came to court and the judge just asked the most sensible question: how can it be that somebody whose needs have deteriorated no longer needs as many hours as she needed a year ago when she was less in need? Had she made some miraculous recovery? Had she found some new and novel way of curing or addressing her need? And of course the answer was no. She hadn't recovered, she had deteriorated. And so the court said that in the absence of convincing reasons, a convincing explanation as to why the need no longer required the same amount of services, the local authority had to maintain, or in her case, increase the package. And the court also said that if you are proposing to make changes like this, you can only do so, you as a local authority, if you have up-to-date information on medical evidence concerning her need. And in her case, there was a significant need for a nursing and occupational therapy report to show what her current situation was, and the local authority didn't have that. One of the most important reasons for having a care plan written down in detail, explaining the how, the when, the why and the where, is so that if things go wrong, we can look at that plan and use it in making representations to the local authority. It may be that services that have been specified are just not being provided. It may be that the people that are coming to deliver the necessary services are really not up to the job. It may be that an adaptation that was arranged was done improperly, and so on. And so we need to go to the care plan and say, look, this is what it says, this hasn't been delivered, and we require this to be rectified. Quite often these days, local authorities won't actually be providing the service, they will be commissioning it from the independent, the private sectors. And not unusually, that service will be substandard. In that situation, we go back to the local authority. We don't go to the independent sector. We can make a complaint to the independent sector, but it's the local authority on which the buck stops. They have the statutory duty to make sure that our needs are met, and if anything is going wrong, they have a duty to monitor that, keep an eye on that, and to have procedures and practices which will correct it. At the end of this talk, which is the materials section, the further materials section, which I'm about to discuss, we have a whole set of documents about how you do make complaints, precedent letters, and also articles and cases in which the courts have spelt out how these should be handled. The final part of this talk is really a reference to further resources and materials, and a slide will follow shortly with details of these follow-up materials. The courts and the Ombudsman and government in guidance has given tremendous detail to care plans and what they must contain, and we've really only been able to give a very brief overview in this talk. Haven't been able to look at care plans for carers, because carers have a right to be assessed and carers have a right to have their needs met and spelled out in a care plan. And there's much more that can be said, and much more is said in the further resources and materials about the detail of direct payments, and particularly personal budgets, which are causing not insignificant problems. So a slide will now appear showing some of those links to which I've referred. Well, I hope that this talk on social care planning, which is one of a series of talks we have in the Social Care Law lecture series, has been of help. I hope also that the resources at the end of the talk, listed in the final slide, will help you find answers to any remaining questions that you have.